Person at the Wexford County Jail, please state your name for the record.
Christopher Lee Bowler.
This is case number 25-5160FY, people of the state of Michigan versus Christopher Lee Bowler. Sir, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes, sir.
I have a complaint that alleges that on or about December 23rd, 2025 in the city of Cadillac in Wexford County, it is alleged in count number 1 that you committed the offense of police officer assaulting, resisting, or obstructing. That is a felony punishable by up to 2 years in prison and/or a fine of $2,000. A consecutive sentence may be imposed if it happened in a place of confinement. Additionally, the prosecution has opted to charge you as a habitual offender fourth offense notice. That means that you have at least 3 prior either attempted or completed felonies in your past. That makes that 2-year felony a 15-year felony. Now, I'm going to state for the record that the prosecution had also charged you in count number 2 with malicious destruction of a building, $1,000 or more, but less than $20,000. The court reviewed the probable cause affidavit this morning, and it on its own, sua sponte, is going to dismiss count number 2 without prejudice, meaning that it can be brought back, because the probable cause affidavit does not make out that count. You have a question, sir?
Yeah, what do you mean by dismiss? It says like not by prejudice. What do you mean by that? Like dismiss not by prejudice.
So I dismiss count number 2
Okay.
without prejudice, which means it can be brought back with more information. Just the affidavit of probable cause that was filed with the court does not make out sufficient enough evidence for that charge to be authorized. But it is possible that it can be authorized in the future. Do you understand that?
Yeah, yep.
You understand then those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to have an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request an appointment of an attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the probable cause conference, prior to the preliminary examination, there'll be a probable cause conference. And that's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing in future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, in 19, I show a false report of a misdemeanor. In 19, operating without security. In 20, a domestic violence, assault and battery, abandon cruelty to 1 animal, malicious destruction of property, 200 to 1,000, an attempt to resist and obstruct. In 21, an attempt to interfere with electronic communication, and in domestic violence. 21, possession of meth. 21, malicious destruction of a building, 200 to 1,000. 21, use of meth. 22, possession of meth. 22, resist and obstruct. 2 are no's out of 23. And in 20, there was a resist and obstruct a conservation officer and use of methamphetamine. It's also my understanding that the defendant is currently on parole. And the praxis scores him at a risk level 6. Comment regarding bond, Mr. Harrison?
It's largely academic in light of the parole hold. We understand it's Agent Simmons. We intend to consult with her, obviously, the potential impact of the disposition of this case. I would have the court set a bond. It's simply in light of the opportunity we may have to resolve the parole hold in a timely fashion, however remote that may be.
Thank you. Ms. Lawrence?
Thank you, Your Honor. I was told that MDOC does want him back. I have very limited information on that, and I'm quite frankly not quite sure how that works, so I am going to ask for a larger monetary bond in the meantime. The defendant, there's some serious issues here. I understand probably some mental health issues, but he was extremely uncooperative with not only the parole agents in this case. He headbutted a wall. He continued to say he was going to kill himself. He threatened to spit on officers. A sergeant actually had to ride in the back of the car with him to the jail because he would not cooperate. This seems to be an ongoing issue given his criminal history, so I do think a monetary bond would be appropriate in this case. I will leave that up to the court. Thank you.
Thank you. Well, the court does find that the defendant is both a flight risk and a threat to the community. I find it as a threat given the domestic violence charges in his past, the interfering with electronic communications, and the civil resist and obstructs in his past. Also, for that same reason, I find him as a flight risk for failure to comply with law enforcement officers. My reading of the probable cause does indicate that he perhaps destroyed a desk in the probation and parole office, put his head in through a wall, or at least broke the drywall while bouncing his head off of it, bounced his head off patrol vehicles. So I do believe a monetary bond is appropriate. Bond will be set at $25,000 cash surety with conditions that you appear as ordered, keep your contact information current, not leave the state without permission to commit no crimes. You must comply with DOC. That you not act in any threatening, intimidating, and harassing behavior, and not to purchase any firearms or weapons. Next, Raymond.
Your Honor, that was the last arraignment.
Well, we've added some bond motions. Person at the Wexford County Jail, please state your name for the record.
Becky Lee Harp.
Thank you. This is case number 254847 SN, the people of the state of Michigan versus Becky Lee Harp. Ms. Harp, you are here for an arraignment on an alleged bond violation. In particular, it alleges that you failed to take, get to the right page here. You failed to take daily alcohol tests as ordered on December 19th and December 21st. That you failed to report weekly and failed to contact Community Corrections Office. That you currently owe Community Corrections $270 and that you failed to take an ETG test as directed on November 20th, November 21st, November 23rd, November 28th, December 11th, December 12th, December 14th, December 15th, December 16th, December 19th, and December 21st. If you are found to be in violation of your bond could be revoked. You also have the right to have a contested hearing in this matter where the prosecutor would have to prove to the court that you did in fact violate your bond conditions. Mr. Harrison, I know this is Mr. Hartel's case. Have you had the opportunity to meet with Ms. Hart?
I have not. I don't know if he did either. He did make the rounds this morning via Zoom.
How are we proceeding today?
Well, at this point, we would have it set for a hearing. Again, I realize that there are multiple allegations here and that the proofs are minimal. I'd just like to know more about the intention of the community corrections as well.
All right. Court will set the matter for a contested hearing. Defendant was arraigned back on the 17th of November with conditions, standard conditions, and should be placed on daily alcohol testing, along with no contacts and no weapons, firearms, or threatening, intimidating, harassing behavior. Comment regarding bond, Mr. Harrison?
Other than the fact that she is a member of the community and it does not appear to be a flight risk despite her apparent lack of attention to her bond requirements, I can't think of a reason why I believe that remand is appropriate here. I would recommend the court reinstate bond release pending the hearing.
Ms. Lawrence?
I am going to ask for remand. I think it's pretty clear based on just the amount of alleged there are. She clearly has not been following the rules. She has not been testing. She has not been keeping in contact with community corrections. And I think this clearly shows that she's not a very good candidate for supervision, at least at this time. So I would ask for a remand pending the hearing. Thank you.
The allegations in this case are domestic violence. The defendant does have some alcohol-related convictions in the past, but those have been set aside. However, given the sheer number of alleged violations in this case, all dealing with testing for alcohol, the court is going to remand. Gail, next to Raymond. You represent yourself or request the appointment of an attorney?
Appointment.
All right, court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I do not show any prior history. Praxis scores her at a risk level 0, and a $250 bond has already been posted. Any additional comment, Mr. Harrison?
I would encourage the court to observe the current bond that's posted. All things considered, she's been an excellent candidate for PR. However, I think the monetary bond, she needed any further incentive, accomplishes that. And of course, if the court deems it necessary to test her, she's more than willing to do that as well. Although she does live in music and travel might be an issue, especially during this kind of weather.
Thank you. Ms. Lawrence?
Thank you. This stemmed from a traffic stop for crossing the center line multiple times, as well as no insurance. There was a PBT done in this case, which came back at a .096. While I understand that is on the lower end compared to some of the things we see, I would still ask for random alcohol testing given the nature of the charges.
Thank you. The court will go ahead and continue the bond as previously set with the following conditions. Ms. Paddock, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you not consume any alcohol, and you'll be subject to random testing. All right. You can go out to the front window where you checked in, get your next court date. You'll probably have some paperwork to fill out for the defender's office, and then go downstairs to community corrections and get signed up for testing.
Okay.
Okay.
All right.
Thank you. All right, court next calls the people of the state of Michigan versus Richard Lee Bowler, case number 255107 SM. Mr. Hartel appears by Zoom. Ms. Carey is approaching. The court today requested that we appear to readdress bond. So sua sponte, the court is bringing this motion. Mr. Bowler has been in jail since his arraignment in this case with a $25,000 cash surety bond. Mr. Hartel, I assume because he's still there, your client is not able to post bond. Is that correct?
That is correct, Your Honor.
Ms. Carey, do you have any comment regarding bond at this time?
Your Honor, I think this case is quite resolvable, and I would remind the court that he has 2 pending felonies that are certain. So we have
Procedurally, is he still at pretrial phase upstairs in circuit court? All right. The court is going to reduce the bond to a 10% bond, so $25,000, 10%. With the same conditions of no contact with Timothy Ayton, not to purchase or possess any firearms or weapons, and not to act any threatening, intimidating, or harassing behavior. Anything else, Mr. Bartel?
No, thank you, Your Honor.
Ms. Carey?
No, thank you.
All right, thank you.